Hello friends, in the series on the income tax cases, today we will discuss an issue which is based on cross-examination of the witnesses, or in other words cross-examination of the persons whose statement is being relied on by the assessing officer during the assessment proceedings of an assessee. The concept of cross-examination becomes more important in cases where the department makes search on some parties, take their statements and uses those statements against the various assessees for doing the assessment against them by relying upon those statements. So, the general principle of natural justice says that if an assessee makes any statement against a person, then the person against whom that statement is being used has a legal right to cross-examine that person, and until and unless that person should be made available to the assessee for doing the cross-examination. So whether this right is available in the income tax proceedings to the assessee is the subject matter of this deliberation. The name of the case is SKM Animal Feeds and Foods India Private Limited, Sivan Ramesh versus Assistant Commissioner of Income Tax and another. This case has been reported in 464 ITR at page number 213, and the matter has been decided by Honorable Madras High Court, and the date of the judgment is 31st October 2023. In the present case, the assessment of the assessee was completed without giving him the opportunity to cross-examine that person on whose statement, and that statement which was used against the assessee was not cross-examined by the assessee, and this opportunity was not given to him. When this matter was before the Madras High Court on the subject of right of cross-examination, the Madras High Court said that it is an important and essential right of the assessee to cross-examine that person whose statement is being relied by the assessing officer. The court said that once the request for cross-examination is made, it is the bounden duty of the assessing officer to give him this right to cross-examine that person. The court also said that the assessee has to prove no justification why he need this cross-examination, because once the revenue is made his mind to use that statement against the assessee, at that point of time itself the assessee is entitled to ask for the cross-examination. Sometimes it happens that the revenue says that if the right to cross-examination is not made available to the assessee at the assessment level, then the CIT appeal has the co-terminus power to give him this right of cross-examination. For this, the court said that the right of cross-examination at the assessing officer level and the right of cross-examination at the CIT appeal level cannot be equated, and this is the right which is to be given to the assessee at the assessing officer level itself. The court said that it is a legal right which should be made available to the assessee before conclusion of the assessment. The court said that if the right of cross-examination is not given to the assessee, then the assessee will be losing his right of a well-considered assessment order. The court also said that the right to cross-examination is very essential to check the veracity of the statements. And in conclusion, the court said that the right to cross-examination is a part of principle of natural justice, and if the assessment order is passed without giving the right to cross-examine, then the order is null and void. In the present case, the importance of electronic devices were also discussed, and the court said that if the electronic devices are relied on, then they should be certified in terms of section 65B of the Indian Evidence Act 1872 and if they are not tested on the touchstone of section 65B of the Indian Evidence Act, then those electronic devices cannot be relied on, and in the present case, since they were not certified according to section 65B of the Indian Evidence Act, so the matter was remanded on this point. So friends, in nutshell, the right of cross-examination is an essential part of assessment proceedings, and it should be our endeavor whenever we are in the assessment process, then we should ask for this right before the assessing officer, that we should be provided the cross-examination of that person on whose statement the learned assessing officer is relying. Thank you, friends.